Good afternoon, my name is Russell Parsons and welcome to this webinar on GDPR, where we will discuss, dissect and deliver a verdict or two on how to tackle what is undoubtedly one of the biggest changes to data-driven marketing communications since the dawn of the digital age, and all in the next hour or so. There's plenty to get through, from profiling and consent to databases and legitimate interest to the cultural, structural and philosophical challenges. The format today is this. I and my esteemed panel, who will intro you to you in a moment, will discuss some of the key issues around GDPR. Then we will hand it over to you to ask our panel what you need to know. You can do so at any time during our discussion or at the end, and please make sure that you do, and we will get through as many as possible before our time is up today. Let me introduce our panel first. Steve Ford, who is Director of Online Product and Marketing at ITV. Welcome, Steve.
Hey.
Shell's General Manager for Data Privacy, Rob French. Welcome, Rob.
Hello.
And Director of Policy and Compliance at the DMA, John Mitchison. Welcome, John.
Hi.
And hello all. I remember when GDPR was first floated way back when, and there were dire warnings at the end of days for many bodies representing the interests of what we used to call direct marketers. So is it the beginning of the end, or is it the start of a brave new world? Steve, I know you probably favour the latter. If I can quote you back at you, you said to us last year, if it feels like it's just being done to satisfy a legal requirement, then it can be daunting and people don't want to engage with it. But if you turn it into something that's actually a brand positive, viewer-centric mission, then people will be more engaged. For many out there trying to unpick what they need to do and what they don't need to do, and how the hell are they going to get there, that might seem perhaps a little utopian. But explain what you mean when you told us that last year.
I come across as being very positive about GDPR because I actually am. I think it's a massive opportunity for all businesses. Certainly for ITV, we're seeing it as an opportunity. It's been 20 years since the last Data Protection Act, and now is an opportunity for us to really have a moment in time when everybody within the business can really focus on it. And actually, it's a great opportunity to really unpick and look at kind of how you're using data across the whole piece. Yes, there's lots to do. Yes, the fines are real. Yes, there's loads of work to be done. But like I say, it's a massive opportunity. It's an opportunity for the organisation to work out what it means in data, to work out what data is being collected, how it's being processed. It's an opportunity to look at how you can be more efficient with that data, drive efficiencies through the business in terms of kind of how you email out, how you hold data and where you kind of process it. So I think there's loads of opportunities there for it. Look, for me, data protection has always come down to two fundamental things, and I think GDPR just tightens up quite a lot of this stuff, which is transparency and control. You are transparent about what data you hold, why you hold it, and how you use it, and you give I'll call them viewers, but you give your consumers controls about how they can interact with you. And I don't think actually those fundamental principles really haven't changed for GDPR, and they've just been a lot of things that have tightened up in terms of kind of what you need to do, and obviously it's now a regulation rather than a directive. So I think those principles still hold true, and if you are already on that road to doing that, then that's great.
John, Rob, is it a brave new world here, or a colossal pain in the arse, or a little bit of both?
Well, It's not the revolution that some people think it is. It is definitely an evolution, to quote the commissioner there. GDPR didn't come out of nowhere. We have had the DPA for 20 years, and GDPR is a natural evolution of that, bearing in mind some of the things that have gone on recently. People are more concerned about how companies are treating their data and, where their data is going and what's happening with it. So I wouldn't have expected anything else to come from, an updated regulation like this. But like Steve said, it's a lot of work for some companies. But those companies that I've spoken to that have already sort of gone through the process and sort of really overhauled all of their marketing and their data collection have, as you said, sort of found it's a very worthwhile exercise. I don't think anybody would have chosen to do it because obviously it's a lot of work and a lot of resource, but having gone through it, it's been very worthwhile for people to fully understand exactly the breadth of the data that they hold, where it's going, what third parties are using it, and going right back to the basics and understanding, why have we got this data? What gives us the right to use it? What do people expect as a result of the exchange of data that we're having?
I mean, from a philosophical point of view, almost then, I know there are, real nuts and bolts of what you need to comply to, but is it an opportunity to reaffirm or reset that relationship, that value exchange, reaffirm your transparency credentials perhaps with your customer base?
Yeah, I think it is. I mean, I think that this notion of complexity and pain comes from your current situation. It comes from where do you start, and I think that's the hardest thing about it. But the opportunity that's been described is huge. And if you're looking at your customer relationships and you're saying, okay, how can I improve them? How can I maintain them? How can I maintain the value that I get from dealing with customers both in B2B and B2C and all your stakeholders, in fact, because of course it's not just about customers. There are many potential consumers, stakeholders of your business, people who perhaps are negative about your business. There are many classifications, employees, contractors, etc., that apply to this, and the opportunity to reset a relationship with them, the opportunity to actually be much better at managing it and be much more honest with them is just huge. But I can understand why people say it's a pain, and I think probably the second aspect compared to as well as where you start from is how do you determine the value of the advice that you're getting, and how do you turn advice into practical action? And the complexity of the advice and the analysis, I think, is ever increasing, and the need to be simple and simplistic about how you approach it is the same. You need to keep it simple. You need to make sure you're being very targeted, and you can see through the things that you've planned.
I mean, sticking with that, I mean, we talked to you, Rob, last year. I mean, one of the biggest challenges is getting the thing embedded. It's obviously a huge challenge, aligning all the relevant parts in an organisation to make sure what needs doing gets done. It's obviously an IT challenge, it's a legal challenge, it's a communications challenge, it's a marketing challenge. I mean, I believe Shell had a sort of three-pronged approach. If you could just talk us through how you approached it and where you are with that right now.
Well, let's hope I can find three. So I'll make up as many as I like.
Anyway.
Well, I think that going back to your original point about engagement and alignment, I think that is the key thing. And there are many opportunities for us all to engage with each other, and I think the people who are finding it most difficult are the ones where that engagement model isn't quite functioning correctly. And when I say correctly, I mean what is correct? Well, there's lots of different ways you can do it, and lots of organisations will do it in different ways. But I think forming a partnership and a sort of fundamental common approach between those different departments is absolutely key. So maybe that is step one, is saying who's involved and how do we make sure that we've got aligned objectives. I think the second thing is you have to have excellent advice. We're lucky in Shell, we have absolutely excellent in-house advice from our legal team. And then you need to actually form a handshake with that advice that says, okay, I'm going to turn that into practical action, and I need you to help me do that, and I then need you to agree with me that the actions I'm taking are the right ones, and that when that comes round to an external discussion, which is the third part, that you're very comfortable as a legal team to actually be representing either in a calm situation or worst case in a crisis situation, that you're very happy representing what we've done as an organisation, describing it and making sure that a regulator, if they're asking, is very happy with what we've done, even if it's under a stressful situation. So I think that's probably the three stages that you were referring to. I think they're absolutely critical, and being a little bit formal about them helps. Yeah, I think just having an informal agreement on how those steps work could get you into trouble. Having some formality around it, including in the internal handshakes, I think is very important, especially if you have to fall back on it and describe something to a regulator.
Steve, very different business, obviously ITV to Shell, but how have you guys gone about making sure that all the various pillars and stakeholders and relevant departments are all lined up?
I think the biggest thing that we're doing is making sure that it's not just someone someone or a department central, because like with every sort of business change, you need to make sure it's embedded throughout the business. And the biggest thing that we've done is made the decision that we will have data champions in each different department and lead data owners, and then within the sub-departments, data owners, so that we can penetrate that through the business to make sure that it's not just, you can't just kind of sit back and sort of rub your hands together and say, actually, that's going to be the kind of central legal team who will be dealing with that. It's all about kind of making sure that it's sort of embedded throughout the business. And as Rob's saying, it's just making sure you've got all the right kind of policies in place. You know, great advice, whether it's from, you know, you're able to pay great lawyers internally to be able to do it, or there's lots of different kind of industry kind of help out there for people to be able to get advice from it. So I think for us, it's all about making sure it's not just about kind of relying on one department, it's about kind of penetrating it throughout the business and making sure that you're kind of doing it. I think the first step of it is around kind of doing the heavy lifting thing first, which is mapping all the data that you've got and the processes that are doing it. If you can do one thing today, kick off that project and start the kind of process of really trying to understand where your data is and how it's being processed. That will give you a real understanding of kind of then what you need to do with it and how it operates. Now that can be done centrally, but kind of, you know, it will need kind of help from all the different parts of the business. That's what we've done anyway.
I mean, there's already a lot of questions coming in, and I thank everybody for posing those, and just remind everybody listening that they can pose questions throughout the webinar. Already there's a couple of themes emerging, and it is in relation to what you just referred to there, Steve, mapping data. I mean, this question of, you know, working out where all your data is and what you should and can keep, you know, whether or not you need to bin some old data, repermission it, etc. I mean, John, is this something, when it comes to existing databases and different platforms and different sources, that you're getting a sense that people are finding difficult? And if so, is there any advice that the DMA is giving to help people manage that data and make sure that some of the legacy data from different sources is all joined up?
Well, certainly the data mapping or a data audit is one of the first steps that I think is very important.
Well, how do you start that? I mean, it sounds absolutely...
Well, yeah, and I suppose it depends on the scale of your business. I mean, we had to do something similar at the DMA, and we're a very small organisation, really, and even that was painful enough. But you just have to consider every department within your organisation and think about the data that they've got. And then it's kind of like who, what, and where, yeah? So who has it, what's done with it, you know, and where does it go, where is it stored? Because as departments and businesses have grown over time, it's not just the case that there's one central database. You know, you'll have maybe one database in one department, a CRM tool somewhere else, and, you know, some of the data from one department moves into another one, and there might be cloud resources. So you do have to talk across the business to every department and every area to understand exactly where all that data is, and that mapping process can take a long time. But I think it's very important. It's fundamental to understanding, and it's fundamental to what the other thing that people were talking about here, about getting in place a number of policies and procedures that describe how that data is used. And that goes back to the principle of accountability, which is kind of like, you know, the new sort of buzzword for GDPR. Accountability meaning that it's not enough to just comply with the regulations, you have to be able to demonstrate that you comply. So if anybody did come and ask you about what was going on with a particular data process or why people were receiving marketing, you could take it right back to the beginning and show them a policy for why you do your marketing in that way, you know, a policy for how long data is stored, a policy for, how it's stored, whether it's locally or, you know, cloud storage. And, you know, there wouldn't be a need to go and do an investigation. You could just point out the various policies. And that level of demonstration is vital, I think.
I mean, for perhaps maybe more smaller companies, certainly than Shell and ITV, I suppose the way that they've collected their data or captured their data might be slightly different, perhaps less organised than in the past. I'm just looking at a question that's come in now, and it is related to B2B. Chris from Ashdale Consulting has asked, I mostly deal with B2B and have email addresses, etc., gained primarily from publicly available sources, websites. How does the new legislation impact on how I use this information? Now, I can imagine that quite a few people out there are in a similar situation from Chris. I mean, where does that leave them with this previously captured data? Anybody's thought?
Well, shall I start with a sort of generic point about handling B2B data? I think that most organisations, if they've got B2B data, probably have some sort of sales process, pipeline process that runs from sort of suspects and prospects through to a contract. And if that is the case, then I think step one is to actually map that process through and actually work out what you're storing, how you got it, and when you start contracting with the particular company that you're dealing with, and how your relationship changes across that sales journey. Because then you can start to apply the rules, which I won't dive into because they're specific. I'll hand that across. But then that puts you in a much better position to have what you will need, which is a slightly different approach, and in some cases quite a different approach, depending on which part of that journey you're in. And then, of course, just there's the dealing with what is B2B data. Certainly in our case, that can also include employee data of the B2B company that we're contracting with. We could be delivering something to an employee of that company, and therefore you're into a crossover point between B2B and B2C data, and you can be actually needing to deal very carefully with that as well. So I'll hand over. That's more of a generic point about sales contracting.
Just a little bit of the the basics about B2B. I mean, GDPR doesn't make any distinction between B2B and B2C. GDPR just talks about personal data. And my email address, which is john.mitchison@DMA, is personal data in the same way that my email address, john.mitchison@yahoo.com, is personal data. So GDPR doesn't make that distinction. But there are requirements in GDPR about the information that needs to be provided to people in privacy notices and their right to unsubscribe and all of that kind of thing. Where the differences between B2B and B2C come into play are in what's currently known as the PECA regulations, or the Privacy and Electronic Communications regulations, and they will be replaced probably in about a year or so by e-privacy. Now, at the moment, if you're contacting B2B data, and when we're talking about B2B here, I'm talking about corporate entities, so limited companies, PLCs, public bodies, that kind of thing. You don't need prior consent in order to contact those people. You will need to make sure that whatever you're sending them is relevant to their job title, and you will need to send an unsubscribe. I'm generally talking in emails here. But when it comes to emails and SMSs, you won't need a pre-existing consent like you would with consumers. The one thing to be cautious of there is, of course, the difference between a corporate entity and an individual, because a sole trader or a partnership is treated as an individual, so you will need to make sure you keep those separate.
Thanks for that. I'm just looking through the questions, and there are plenty coming in. Thank you very much for posing those. And consent is coming up time and time again. So, I remember when I first started reporting on GDPR, as I say, it seems like an age ago now. Consent absolutely dominated the early part of the conversation. And it seems as though it's very much dominating people's thoughts right at the end of the process, if you like, given May is the compliance date that we all need to think about. John, just continuing with you, I'll ask a few sort of general questions that hopefully capture some of the specific queries that people have been asking. How granular does it need to be, consent? People are asking questions about consent for this, consent for that, consent for the other. Is it just as simple as, well, to my mind, doing the right thing? Are you making sure that you get explicit buy-in from anybody that you're going to communicate with? Or is it am I being incredibly naive and you have to have consent for this in this way and consent for this in this way and consent for that another?
Well, this is one of the areas where, in a way, we're quite lucky with GDPR. The GDPR text that we've got is probably about as business friendly as we could have hoped for. Previous versions were not this good, right? So GDPR is a principles-based piece of regulation.
They're the worst kind,
well,
aren't they?
Well,
just tell me what I need to do.
Well,
joke.
Well, you could think of it like that. You know, some people like rules. You know, do it like this, do it.
Yeah,
like that. And that's quite easy. But when it's principles based, it basically means you have to make a kind of a business decision for yourself. So when it comes down to things like granularity, it's up to you to decide, really. I mean, if you've got say a product range which is incredibly diverse. I always use the example of the co-op here, right? Because they've got supermarkets and they've got insurance products and they've got funerals, right? And you might think that if you signed up to hear about, supermarket products, you wouldn't naturally expect to receive something about funerals or insurance, right? So in that case, yes, you would need to break those down and maybe have separate opt-ins for each of those. But if you were an insurance company that just did, say, house insurance and contents and property insurance, that might be suitable to lump together, because if a person was talking about insurance, they might assume that property and contents insurance would be a likely thing to receive. So it's just down to you to justify it, and that comes back to the principle of accountability. When you're setting out your process for that particular piece of marketing, you document why you did it that way, and if you can sort of justify it to yourself without having to pull a funny face, you're probably doing it the right way.
I mean, I think probably at least 60% of the questions that we've received so far are about consent, and I was joking there about principles-based, but maybe that's the reason that we've got so many very specific, granular questions about particular different things. I mean, Steve, this when it comes to consent, I mean, are you guys dealing with it more philosophically almost, that consent seems to be the absolute basic requirement when you are looking to build this trust and transparency?
Yeah, I mean, completely.
That you have their buying, and if you don't, then why are you doing it anyway, regardless of what the GDPR does or doesn't need you to do?
Completely. I mean, look, consent under Data Protection Act has moved from there now to kind of being more about kind of informed, clear, affirmative action. So kind of it's what GDPR has done is kind of really cleared up some of those sort of grey areas where there was pre-tick boxes that brands were using, and it's kind of always, for me, that's always been a little bit of a weird thing to do, is to sort of trick your consumer into thinking that, into kind of getting them to opt in. And I just found, what the brands that I saw that were using that actually were kind of throwing good money after bad, because they were kind of emailing people out, and actually most of them weren't responding to it. So I think what this does is it clears up quite a lot of that to kind of make sure that it's a clear affirmative. You have to opt in. You have to kind of tick the box and say I want to opt in. And I think that's really important. I think a lot of brands have actually come unstuck and been having to dump data as a result of it, or kind of reaffirm people or re-consent people. But I think in terms of kind of going granular, I think as long as you're very clear to what you're asking people to opt into, how you're then going to communicate with them, not saying to them we're going to email you and then send them an SMS or a kind of or do something else. I think as long as you're very clear with that and you're really clear in terms of kind of what you're going to be talking to them about, I think it's the same as what we were talking about before with the co-op side of things. Yeah. For us, we have an opt-in for kind of program-related material, and that means that we've got a little bit of scope within there to be able to talk to them about particular programs that we know that they like, and then maybe some kind of things that are spun off from there. So if it's someone likes Coronation Street, believe me, there are still people who like Coronation Street, a lot of them, and then we have a kind of an experience that they can go to and see in Manchester. So there's an elasticity there that you can see that kind of works. But going beyond that to sort of start talking to them about other kind of things is a bit more tricky. Yeah,
I'd like to just sort of like step in there and sort of play devil's advocate a little bit, because consent, because we're not necessarily talking about sending out marketing. That's not what we're gathering consent for, really. We're gathering consent for processing of data, which may be sending of marketing, and consent is only one of the grounds for processing data. And the other one, which is quite useful for marketers in particular, is legitimate interest. Okay? So If you have a relationship with somebody, then you might be able to justify a legitimate interest, which would mean that you didn't have to gather consent. Okay, consent is quite difficult to gather. People don't always want to tick that box, and ongoing, it requires maintenance. There are more. It's more difficult standard to achieve. And legitimate interest, you can use legitimate interest for sending marketing. So if you were using traditional channels in the main, obviously post and telephone, you could still have an opt-out box and use legitimate interest. But then there are other things as well that you could use legitimate interest for. So you might collect consent to send the email, but you might use legitimate interest to process that person's data for data profiling, right? So the two work together, often in the same sort of scenario.
It's a question that has come up, or I'm going to interpret a couple of people's responses to wanting to understand legitimate interests a little bit more. You made a very important distinction there about this is not about consent per se for marketing communications, it's about data processing, and legitimate interest seems to me to be not an alternative but another way of looking at it. People are actually asking, what does it mean, and can I rely on that and not consent?
Consent is much easier for people to understand because it's a tick box, right?
I was going to say.
Do you want to receive marketing from us? Tick here, okay. With legitimate interest, you have to go through a bit of a thinking process with it. First, in most cases, you will have to show that you've got a relationship with the person, and a relationship might be a customer or somebody that's entered into negotiations with you, and then you have to sort of do this balancing test where you weigh up the rights of your business, your legitimate interest as a business to send marketing or process data, and the rights of the individual to not have that happen. Now, you've got to remember that GDPR is written for all kinds of data. Okay, it might be medical research or denying somebody a loan or something like that. So in marketing, it's not that difficult to sort of make that justification that it's okay to send out marketing, and as long as you provide an unsubscribe along the way, then it shouldn't be too difficult to get your legitimate interest case across.
Again, practical point. You want to be doing that at the point at which you're designing the activity, and making sure you've got a good record of how you came to that conclusion and which interests you're using. You don't really want to be making it up in the face of questions from customers or from regulators.
Absolutely. Yeah.
Legitimate interest is if there's a reasonable expectation that data will be processed as part of the experience that you have, and to your point, it's about kind of considering the impact that has to the viewer. If you're in your data impact assessment, it's a low impact, then you can consider it. But I think the key thing is to be very clear and transparent in your privacy notices that you're doing that. And you can go belt and braces and have some kind of opt-out as well if you want to go down that route, which is kind of offers that opportunity to say, look, we have a legitimate interest to process your data, but if you really don't want us to do it, here's an opportunity for you to kind of opt out over here.
Sure.
And you made a great point about the sort of increasing sophistication of different activities and building relationships with customers or with consumers and non-consumers of your business. You are, I think we're all seeing increasingly sophisticated relationship building that stretches the boundaries of these kind of historic relationships that you would have had, these historic ways of looking at getting consent. If you're trying to build that relationship and build an experience for them, and actually that's the customer expectation, you really have to understand these different ways of looking at it, and you really have to continue to work with them rather than against them, because otherwise you actually end up with quite a bland customer interaction, because you've bounded yourself by some feeling that I need a tick box, and it's all about the tick box. It's not. It's about the relationship, the experience, and the value that you're transmitting, and then of course the legal basis for doing that.
Somebody's made an observation here, though. As much as I appreciate, and I'm sure everybody else listening appreciates your observations, she's just making the observation here that how the hell is it going to be policed then if it's so principle-based? But anyway, we'll move on from that and talk about profiling.
Well,
I think it's worth talking about.
At its simplest, GDPR is policed by people whose data is being processed, right? The ICO is a risk-based regulator, so they investigate complaints. If your marketing generates complaints, you will likely be investigated. So how you determine what is a legitimate interest and what is reasonable is up to you to decide. You know your customers, you know the kind of things that they would be expecting from you. If you get it wrong, you tend to know that because you hear from those people.
Yeah, lots of people saying similar things, just looking through the questions, and thanks for everybody who has posed them. Just talking about legitimate interests has been a grey area, etc. But I think we've got to a place where it's about the right thing for you, the right thing for your customers, the right thing for your company, and as long as you are, I don't want to keep using this phrase, ticking those boxes. This is not about box ticking.
But there is
clearly a lot of concern out there about legitimate interests, is what I'm saying, I suppose.
The legitimate interest and consent is one of many legal reasons why you can process data. So it's worth looking at the kind of advice out there, at the other ones as well, to see whether any of them fit with your business. Consent is the one that's easiest to understand, but it's also got to be freely given and actually can be taken away at any time. So, really do look at kind of all the options that you've got to kind of process that data and really sort of see whether your business can fit with it.
Okay, I'm just going to part legitimate interest for a moment, but it seems like each and every one of these areas that we're going to move through and that people are asking questions, you could do a whole day on every single one of them. In all my time as writing about marketing services, I've never ever come across something that has, well, it's not a case of polarising, but as captured. And after all of this, I think people will be in a much better place in terms of transparency and trust and that contract and value exchange. But there's obviously quite a lot between now and May and beyond that people need to catch up with. So let's move on anyway. Talk about profiling. As everybody who's subscribed to the careful segmentation and targeting of customers will attest to, it's obviously a big part of marketing. I mean, how will GDPR impact people's ability to segment and target? What level of automation is required, and how detailed should you be in explaining what you're doing? So, in the context of profiling, in particular segmentation and targeting, is there anything within GDPR that people need to think about differently?
Well, if everybody who's doing any kind of marketing does some kind of profiling. I mean, at its simplest, it is what you said. It's just segmentation. You might send a different offer to under 30s as to over 30s. So technically you're kind of profiling the data. At the other end of the spectrum, you might be going out to third-party organisations and getting additional data variables to add to your existing records. You might be using products like Mosaic or Acorn or Personix or anything like that to add geodemographic stuff as well. But it's the important thing to remember is whatever you're doing is that you need to let the consumers know. So in your privacy policy, you would explain what you're doing. And it's not just enough to say, oh yeah, we do profiling. You have to say something meaningful that genuinely explains what's going on with the person, with that person's data and what additional data you're adding to it. Now, in most cases with marketing profiling, it's relatively benign, and you could probably get away with that using legitimate interest. So as long as you mention it in a privacy policy and tell people that they can object to their data being profiled if they really want to. You don't have to put a tick box or anything with it. You can just say that that's the case. Then you can get away with it. But if you're doing particularly intrusive or extensive profiling, then you might have to go as far as putting a tick box on there and actually getting consent for it.
Thank you for that. I'm just running through the questions, and there's so many of them. I think I'm just going to turn my attention now. There are so many different areas that are covered off in these questions. So I'm going to get through, and this is for everybody listening, as many as I possibly can. Catherine has asked this. I'm going to read her question in full. It's quite lengthy. As a marketer at a mid-sized B2B company, where does the responsibility lie with how data is held and processed in other areas of the business, such as finance, customer services, or even sales? Would you recommend marketers to be the torchbearers in cleaning up processes across the business, or should it be handled separately by business area? Steve, let me start with you as a marketer. Should this be something that marketers should wrestle hold of and lead the charge for the rest of the business?
Look, as brand custodians, marketers are the ones who can. I would say if there's nobody else in your business who's doing that and taking that mantle, then now's the time to step up and say, you know, this is the time to do it. As I said before, it shouldn't be centrally held, and it shouldn't be kind of said that somebody, there you go, it's up to you, person A or department A to do it. But I would say that, look, if in all those different areas, if data is being processed, you're considered the data controller. So the different departments are considered the data controller. So they, therefore, as a marketeer, I would say, look, if no one else is interested, then you should be the one stepping up and saying this is really important. We need to get this under control. Not just about marketing and consumer stuff. It's about kind of how our business works with data overall, whether that's kind of HR, whether that's finance or whatever. You know, you need to be kind of really sort of kind of stepping up to that, I think.
Thank you for that. Rob?
Well, I was similar. I think if it's marketing, I'd always say, you know, there's a competence, capability, and opportunity lens to put on it. If I think marketing have got to lead the charge if no one else is, but I would hope that Catherine can get some management attention on it as well as doing her job, because she's probably adding a lot of value in her job and probably hasn't got the time or capability to go off and fix every problem. So perhaps a two-pronged attack, in terms of using the data, saying the right things, and trying to get some management attention, which puts resources in the right place.
Thank you for that. There's a couple of questions actually around social media. And its use as a comms channel, both direct to consumer, but obviously in terms of information gathering, insight. I mean, social obviously has been used more and more for communication, both and as an insight tool. Is there anything at all that people need to be particularly, I wouldn't say concerned because that's quite pejorative, but aware of when it comes to social media use for communications and for data capture, that perhaps is different from more traditional DM, like email, etc.?
Well, I think some of the big social media companies like Facebook, to name one, are obviously going to be, they're kind of struggling with this, and I think they've issued some new privacy setup within their European systems at the moment, which are trying to cover GDPR. But if you're going to be using your customers' data within a social media, some people use like Facebook lookalikes and retargeting and that kind of thing. If you're going to be doing that, then of course you just need to let people know that that's how their data is going to be used. When people sign up to Facebook, they obviously, there's their own sign up to Facebook and the relationship and the privacy policy within there. So I think it's going to work its way out quite nicely, I think, with social media. But if you're putting your own customers' data into it, you just need to let them know. That's a privacy policy issue for you.
Thank you. I'm going to try to rattle through a lot more of these questions. This is a question, I suppose, in relation to geographical spread, and particularly those companies who are operating across multiple territories. How are you, and I'm guessing you means you guys, treating GDPR in offices outside of Europe? Are you applying the same processes and treating all customer data the same way, even if it is not data of an EU citizen? That's a really interesting one, particularly given the geographical spread of a lot of companies. Shell obviously operates in multiple territories. How's it working there?
Yeah, so sort of 200 territories. So yes, we are doing it one way. We have binding corporate rules and one data privacy manual that's locked into a code of conduct that applies to every employee contractor that works with or is employed by the company. So we have one size fits all and one lead regulator in the Netherlands. What I would say though is clearly, and obviously the fines are global turnover, right? So it's not, we can't argue that we can escape that. So we're used to this. Having said that, and I think other organisations will be as well. So there are other things like anti-bribery and corruption that would apply globally and have global standards in such a complex organisation. I'm sure others do as well. The other, perhaps the nuance that I put on that, because it's not quite as easy as that, there are obviously geographies where more perhaps localization laws, shall I put them, have been introduced, which are asking for data to be copied or stored locally. They need special attention. Doesn't change the sort of one-size-fits-all way we're doing it. And there are also other areas with local regulations that might be based on the EU, but they've got different names, they've got different regulators. South Africa is one actually that we were talking to this morning. And actually what we're doing with them is running through a sort of delta process just to work out, do you have anything that's actually different, that needs a specific action, and if you do, let's record how we've come to our conclusion and what we're going to do, if anything, and then obviously go and do it. And perhaps the last point I would make is that one size fits all is not an excuse for heading for the bottom. It's an excuse for setting the bar. It's a way of setting the bar high. And I think that anyone who's using it as a sort of lowest common denominator argument is probably going in the wrong direction.
Thank you for that. Third-party data and third-party interaction has come up quite a few times, and it's obviously a big. I mean, everybody's looking for that first-party data golden nugget, but most companies are relying on third-party data. I'm going to ask a specific question, but then we'll perhaps talk more widely about third-party advice, perhaps something you can speak to, John. Michael has asked this question: if the data owner is sending a third-party email on our behalf, do all recipients have to have explicitly stated that they wish to receive information regarding my company? It's a very precise question. I don't know, John, if that's something that you can speak to, but this question of third-party, particularly B2B again, I think it's probably particularly relevant to. Is there any specific or general?
Somebody was sending an email
so
on
if
his
the data
behalf.
owner is sending a third-party email on our behalf.
Okay, so I think that's in like.
Do all recipients have to have explicitly stated that they wish to receive information regarding my company? So that's.
Yeah, I think what's being described there might be describing a hosted email, if it's being sent on behalf.
That's how I'm interpreting it, anyway.
In most cases, if you're sending emails, then you almost certainly have to use the consent legal ground.
Yeah.
And in consent, it says that consent has to be named, and it's almost certain there is still one last piece of guidance to come out of Europe from the Article 29 Working Party, but it's almost certain that they will go ahead and follow that rule, that consent has to be named. So if you're sending, or if you're passing on data to a third party, then you have to name that third party. If that third party is using it for marketing. Outsourcers are not classed as third parties in this. With the hosted email route, if the sender of that email is sending it out under their own name, but just sort of saying, oh, hi, you signed up to our website to hear about, gardening offers or whatever it is, here's a gardening offer that we think you might like, and that offer is from another company, then I don't think that that company will have to be named, but the person will have had to have given consent for particular categories of marketing, in this case gardening. I'm just using that as an example.
Thank you. I'm just looking down the list of questions. Third party came up quite a few times, so thank you very much for that. There's also quite a lot of questions. I mean, I think even my meagre appreciation of the specifics of GDPR can answer these, but lots of questions about small companies. Genuinely questions about how much of it applies to them. But more specifically questions not so much about small companies, but those perhaps not-for-profits or charities, and whether or not there's anything specific advice-wise that anybody can offer them. I mean, I guess the principles are the principles, But I mean, sorry, sticking with you for a moment, John, and then I'll broaden it out, perhaps. Is there? I'm guessing a lot of your members are charities.
Yep.
Is there anything at all who absolutely rely on databases and donor databases? Is there anything that you can offer by way of navigation specifically for those people?
Well, like you said, the GDPR is there for everybody. You can't really get away from it. There is some specific charity advice. We have some charity advice on the DMA website. The ICO did an FAQ specifically for charities and fundraisers recently, where they drew attention to the legitimate interest ground for marketing, because a lot of charities do a lot of direct mail, and they won't, or they might not have collected consent in the past, so they can continue to use the data that they have collected. Also, the fundraising regulator has some guidance coming out. So actually, I mean, as a sector, I think they've got quite a lot of good quality guidance available to them.
Thank you for that. Somebody asking.
I mean, can I just make a quick? I was just going to make a quick point. Actually, I mean, this is an interesting area, and it pervades obviously everything. To the point where a sports club that I'm a member of obviously saw my job title, because that's one of the questions on the form, and then asked me some questions about what they should do. And I think that that they're great questions, but actually when you break it down, there's a lot behind this as well about data security, how are you holding data, who's got access to it, and what do you do with it. And I think some fundamental questions for any company of any size are those. If you feel that you're not being responsible with data that you've collected, and that you would be embarrassed or destroyed as a business by having a situation where that went beyond your control, then I think you need to be looking at it. And let's not any of us use a kind of piece of regulation as an excuse to follow common sense and good practice, however big you are or small.
Yeah.
Russell, you just said something about Brexit. Brexit makes no difference.
No, I mean, somebody's asked. It was a question I had to ask myself when Brexit happened. Well, what happens to GDPR? One person has asked. I think the message has got through, loud and clear that.
Well, we're still going to be in Europe at the point it comes out, and the ICO and the Information Commissioner has come out and said we will have a level of data protection the same, if not equivalent, if not more kind of stringent than GDPR. And also, if your business is doing business within the European countries, you'll have to have the same sort of codes for it. So it makes no difference at all.
Thank you for that. There are far too many questions for us to get through in this session. I'm astounded and really appreciative of everybody listening who's posed those questions. Thank you very much, and I apologise in advance that we're not going to get through all of these questions. As I said earlier, we could be at this for days. So I'm going to try and bring it to some kind of conclusion. But just picking up on a question that somebody has asked, and it relates to something that you mentioned to me on the way in, John, or before we started today, about how you'd heard somebody on the bus talking about GDPR and they won't be able to do that. It's coming. There's going to be a change. I mean, it's a genuine. A couple of people have asked about the average person on the street and whether or not this is permeating to them. I mean, it's a decent question for you all, really, about again speaking to that value exchange and that opportunity, perhaps, just to do the right thing for customers, as opposed to getting too caught up in the legal requirements of it all. I mean, is this? How do you communicate it to customers if they don't know? I mean, clearly the people on the number 8 bus are fully versed in data protection, but I mean, how much do you need to tell? How much should you tell? How much is it an opportunity to actually go out and say, this is happening, we've already been doing this, we're going to be doing things differently? I mean, how do you communicate it to your customer base?
I think brands are already starting to do it. I mean, I've got about 25 emails, I think, from different brands getting recommissions from me. I had one from Man United recently. EasyJet have done some stuff recently as well.
Did it feel quite cold and transactional?
Your purchasing behaviour here.
There you go. Yeah, no, exactly. Yeah.
This thing of reconsent and retrospective consent. I mean, everybody can do that. But did it feel quite cold? Did it feel like quite transactional, or did it feel like?
No, I felt EasyJet have just done a viewer promise type thing where they've kind of gone out and said this is how we deal with your data, and I think we're going to see a lot more brands who will be doing that. And I think when it does move into GDPR, there'll be a lot of volume about it. There'll be a lot of kind of media attention around it for a short period of time, and then it might die off. But I think it's only a good thing for consumers to be able to really understand how their data is being used and what's been done with it. So, I think there's an opportunity as brands to actually kind of be more transparent, and the more confident you can be about what you're doing with data, the more transparent you can be, and I think that can only be a good thing for consumers.
I think a couple of points. I mean, this is a marketing conversation that we're having here. It's an opportunity to create a really good conversation, a really effective conversation, and something that enhances your relationship with your consumers. Now, I think that's independent of whether you're taking a very strong position, a very sort of in-your-face, trust us positioning, or whether you're doing what needs to be done. It can still be done in a very clever and way which enhances the marketing you're doing. So it's an opportunity marketing, I guess, would be my first point. The second one I'd return to is, marketing relationships are about building valuable relationships with customers, making a profit, whether you're not-for-profit or profit-making. You're trying to build revenue, trying to make sure that you enhance your position, and to do that in an ever more sophisticated marketing arena, you have to stand out and you have to be innovative. And if you're doing that, you're going to push the boundaries of these things. You're going to get on the edge of them. And to do that, I think cleverly, to stay ahead of it, means you have to understand. And therefore, I think being good at this is not about a 25th of May deadline. It's about being very, very positive and informed and articulate about how you deal with consumers and their data, and if you do that, you can build value for your company.
Thank you, Rob. John?
In a way, it's a new regulation, and everybody's going to be affected. But there's no real need to tell consumers about it. I mean, they should just start to see it in improved marketing that they receive, and less bad stuff happening with their data that they were previously unaware of. That said, the ICO are actually going through a process at the moment to sort of like develop an awareness program. So they will be letting consumers know. But really, it should just be a natural evolution of better marketing, better communication, better relationships with customers.
Thank you for that. Just by way of concluding today. For everybody out there listening who's wanting more information, hopefully they've got that from today. But if there's one thing, one resource, one tip, one trick that you would recommend for people between now and May, I know it's difficult to distill it down to one thing, but anybody wants to kick us off? Speechless.
Well, it's impossible to pin it down to one thing, but don't let the fact that there might not be, you might not be able to find the exact answer to your precise question prevent you from doing something. A lot of people, were hanging on for guidance from the ICO. These full sets of guidance documentation aren't published anywhere yet. But as long as you get on and do something, make a decision, document it, get on with it. If at a later stage somebody questions you about that decision, but you've gone through the accountability process, maybe you did a privacy impact assessment or whatever, and you can justify it, even if the final result is deemed to be wrong, if you can kind of show you're working, it's unlikely you'll get into trouble. You'll just be asked not to do it or to change the process. So just make sure you're doing something rather than nothing when it comes to GDPR.
I guess a couple of points for me. One is it's an evolving picture, so don't just focus on 25th of May. This is going to evolve. It's going to change. I would think all of us watch the environment around us as a device comes out, as John said, as people take innovative and clever positions on things. Watch, learn, shamelessly copy.
Yeah, I think we already said it as well earlier, where we said, start mapping and understanding where your data is held. That the value in that is, it won't be wasted because it counts to your accountability and things like that. So I think do that. Develop a clear data retention policy. One of your aims should be to kind of minimise the amount of personal data that you hold. So it's the efficient stuff that you actually need, and kind of I think that those are the two things really. Kind of map your data and have a clear data retention policy.
Thank you, Steve, and thank you, Rob and John. That was fantastic. I'm going to bring it to a conclusion. That's our hour almost up. Thank you very much for tuning in. There were quite a few questions to this effect, which was, can we listen to this afterwards? The answer is yes, for all those that either came on late or that might want to share it with colleagues at a later date. Can't say for certain when that will be, but we're hoping by the end of this week that will be available. It will be available via marketingweek.com. So look out for the URL via our social media channels. So thanks for everybody again for taking part. There is more information and more resource from us. If you just allow me a plug for a moment, you should see on your screen a URL and a promotional code even, GDPR Essentials for Marketers online classroom, which is brought to you by Marketing Week's sister title, eConsultancy, and you'll hear a lot more, and I stress a lot more about GDPR on our own channels via marketingweek.com and in our magazine and social over the next couple of months. So thank you very much again. Don't be afraid. It seems like there's plenty out there to obviously be getting on with, but plenty of resource and plenty of information. No shortage of that available, and it really does appear to be an opportunity to reset and an opportunity to reaffirm those relationships with customers and do the right thing by them. Might seem very utopian, a little bit romantic on my part, but take that as a positive spring in your step. As I say, my name is Russell Parsons. I'm the editor of Marketing Week, and thanks everybody for listening. Goodbye.